I know a question that all people have is, how do you get paid? What's it going to cost? I'd like to point out in the beginning that my contract is usually different than most contracts that other attorneys have in two ways. Number one, my contract allows you to walk away at any time before I've gotten an offer on your case or before I've taken your case to court, and it doesn't cost you anything in terms of fees. Most lawyers have a clause in their contract that says, look, if you terminate us because you don't like us or for whatever reason, we're going to charge you an hourly rate for the work we've done. I don't have that. The other thing is I advance all cost. All attorneys are going to charge you a contingency fee, and a contingency fee is a commission. The standard contingency fee and what we charge is a third if your case settles and 40% if your case goes to trial. Where we're different than most law firms is that we advance cost. Most law firms make you pay the cost as they're incurred. So if they write, or if they write for your medical records, and the doctor charges them $50, they charge you $50 and they make you pay right away. And it's not that important to have an attorney that advances costs in the beginning of a case because most cases settle with less than $300 to $400 in cost. Where it's important is if your case won't settle because the insurance company is not being fair with you. To try a simple auto accident case costs $3,000 to $4,000. The law firms that make you pay the costs as they go will make you pay that money up front. We don't. We'll advance those costs and get it back at the end of your case. So the standard contingency fee that we charge is a third if your case settles, 40% if your case goes to trial, plus we advance all costs. A lot of times people ask me, well, what happens if we lose the case? Do I have to pay you the cost back? The ethical rules in the state of Oregon requires us to tell the client that they're ultimately responsible for the cost at the end of the case. However, there's an exception to that rule, and that rule states that if the client is unable to pay those costs, you don't have to collect it. And so if you don't have the ability to repay us, we don't collect the cost from you. And we usually make that determination and that guarantee at the beginning of the case. So when I sit down and meet with you, I kind of get an understanding of what your financial situation is, and I write on the side of your contract, we've talked, and you don't have to pay back the cost regardless of whether or not we win your case because you don't have the ability to do so.